Coming up on this program, we show you how to get connected. Find out how to choose an internet service provider. Discover the newest form of communication, electronic mail.
Ways down and ready to ride. One by one, billion by billion, been holding up half the sky. Raise your hand if you're ready and willing. If you know it's time. Time for a girl on time. Time for a girl on time. Time for
Hello, everybody. I hope you are all doing well. Cheers to us. Sorry, I'm a titch late. 5 minutes late, 6 minutes late. I was busy, and now I'm here with you. So the good news is, like I said, we're here with you. We have, oh yeah, Smokey says, keep it green. You have this shirt, Andy? I just got this shirt. My sister gave it to me today. Okay. I hope that everybody's doing well. We have some court to watch, and it is I'm gonna make a video about it. I would have already, but like I said, I went to visit my sister and her baby. I have loved on the baby for a couple of hours, which I love, of course. She asked me if I wanted any more babies. I laughed so hard, so hard. But you know, she's at 10 weeks postpartum, or the baby's 10 weeks old, so she's still smitten as a kitten. Anyways, the baby is doing wonderfully. He has red hair and it is so adorably sweet. I fed him a bottle, which I've never really done before. My daughter never took bottles, so it was a real fun experience. That's so sweet. I guess I sort of like hogged all of the feeding of the baby, but whatever. Anyways, not like her baby. I'm talking about my baby when she was young, 15 years ago. Anyways, these people that we're about to see are involved in a divorce. And I thought about it earlier. I was talking to somebody about it and I said, the guy in this seems what did I say? Reasonable and unrepresented, which is a bit of a dangerous way to be in a divorce. So, keep that in mind. But this is somewhat like a story that unravels itself over time. And it's in front of Judge Bronlick. And I think we'll enjoy it. So, before we finally get started, tell me what you're having to drink or eat tonight, what you had for dinner. If you didn't like what you had for dinner, go ahead and tell me what you wish you had for dinner. You can try and guess the baby's name, but we'll keep the baby at Plaid to make my sister happy, just in case. I have to pretend like one day I'll have 100,000 subs and somebody will actually be looking at these and like ratting me out to my sister if I fuck it up. I'm hoping that my celebrity gets that big. I'm so full of myself. Anyways, but honestly, I do respect her for doing that. She really doesn't even like do Facebook, and that's totally great. Little Red or Plaid. Um, honestly, we could call him Spicy Burrito. Spicy Burrito is what she's calling him, and he is so freaking adorable. But with his red hair, Spicy Burrito, I made him laugh today by asking him what he wanted on his burrito. I was like, "Would you like extra guacamole, Spicy Burrito?" And he did a little giggle, and I say, you know what? Spicy burrito. And then I ate his toes and he loved that. I mean, I love babies. I love them. He even puked on me and I was fine with it. My sister, yes, is dining room court chats. That's correct. I love that actually. Um, my sister and I are so opposite in some ways. Actually, I should have grabbed some of those pictures. We were looking at some old pictures. I should have brought some of those back home here, but I'll grab them next week. Anyways, okay. Like I said before, little bit of a strange situation that we're gonna check out here, and then we'll watch a docket that I haven't even watched any part of. So we'll unravel that one together. But first, without further ado, with me and you, let's go. Into the courtroom we go. So keep note, watch the beginning of this. That's mom, mom's lawyer, there's dad. Listen up.
Hi, Leah.
Hi.
How are you, dear? Good. I got Asher's T-ball pictures here.
Good.
Welcome back. I know that was sort of creepy. MB, it gets creepier when sorry, lost the pen already. It gets creepier in a moment here when this case really gets going. Welcome, Colin and Colin Raiders. You're in perfect timing. We're just about to start this divorce finalization case. And spoiler alert, the gentleman down here is not represented, and her lawyer right here, she's a little mean to him.
For the record, this matter is before the court for entry of a proposed consent judgment of divorce. This hearing is being conducted via Zoom. Attorney Kirsten Nemec is present, representing the plaintiff Leah Frank. Ms. Frank is present, as is the defendant Anthony Frank. Good afternoon, everyone.
Good afternoon, Your Honor.
Afternoon.
Parties were before the court on May 31st for a pretrial conference, as well as enter this judgment. The court had a conversation about the waiver of the 6-month statutory waiting period. Ms. Frank indicated there was no chance of reconciliation, and she was asking the court to do so. She stated it was in the best interest of the children. The final.
Okay, first of all, thank you to Gecko Chaser for 2 months and Colin for 5 months. Thank you for the raid too, Colin. If you guys aren't subbed yet, please subscribe. We are trying to get to 2K. And I would love it if you would join the 2K club. Let me say thank you. And to Gecko Chaser, I'm glad you're feeling better. Oh my gosh, I can't believe there 6 months that I see that right. I love you guys so much. Oh, I love it. I love it. I love it. Thank you. Thank you. Thank you. Hold on. Uh, love it. Thank you all so much. And thank you for being here. We are going to, oh geez, okay. Oh, and Sean became a new member. Yay. Thank you, Sean. members only Sundays, right after our Sunday Court Watchers Anonymous meeting. So anyways, let's continue on. Aw, thanks, Miss K, no worries. Have a good one. Let's continue on with the court, shall we?
Finalizing sooner than later. Mr. Frank was hesitant, and which the court could still have granted, but Mr. Frank seemed he suggested he was being rushed into enter his judgment. So the court adjourned the matter to July 19th, so Mr. Frank could talk to an attorney. My understanding is Mr. Frank has joined this request to have a matter brought before the court this afternoon. Is that correct, Mr. Frank?
Yes.
Okay. Have you had a chance to talk to an attorney?
I'm on the Asher, no. No, I didn't need to. I'm settled with the matter.
Okay. So what do you want the court to do this afternoon?
We're gonna proceed and finalize this.
Okay. So let's pick up where we left off. There's a statutory 6-month waiting period.
So if you're just getting here, what's happening is these two are trying to get a divorce, and there's a waiting period in Michigan that you must wait through that they are asking to be waived. Also, we love noises around here, don't we? Thank you, MB. So this is a definite interesting situation. Also, oh, Drunk Beaver, thank you so much. For as little as $1, you too can make noises come out of your computer from my computer to you. Also, yeah, you're gonna the lawyer right here, she gets a little bit snippy, and like I said at the beginning, you might have missed it. He, I feel, is agreeable and unrepresented, which is a bit of a dangerous way to be. Oh, Jim, you are so sweet. Thank you so much. Guys, members only Sunday after our Sunday Court Watchers Anonymous meeting. That's for everybody, and we don't try and get you to stop watching court. We get there. So yeah, the waiting period, and this is why it's interesting because he's very amenable to a lot of what she's saying here. You're gonna hear he's giving quite a bit, but well, let's just listen. Let's listen together. Thank you again to everybody.
It's 6 months begins to run the date that the divorce complaint was filed. The divorce complaint was filed by Leah on February 20th. So it expires August 20th. This court has the authority to shorten that and waive that. And generally it's in the best interest of the parties and children to move forward unless you really think there's a chance of reconciliation. Or there's a reason like Ms. Frank needs the health insurance through your employer and has a medical procedure coming up. So Mrs. Frank is requesting the court, rather than sit on this till August 20th, she's asked the court to enter the judgment of divorce without delay. Are you today asking the same thing?
So he came in last week, Legal Fiction. First of all, thank you. And he was so hesitant last week that the judge pushed it off for a week. So now they're here again, and he has to ask him again, are you sure that there's no chance of reconciliation? She does look a bit like a statue can be. Thank you again, guys.
I am.
Mr. Frank, let me ask, obviously Ms. Frank is still asking the same. Mr. Frank, are you asking the court to waive the balance of waiting period and enter the judgment of divorce today?
I'm agreeing to it. Yes.
Okay. Again, you seem to suggest you're being rushed into things. You've had now another week to review this judgment, all the terms and conditions. If you not finalize things, if you want to change your mind, you can change your mind today and say, I want to renegotiate some of these terms. You understand?
No, I'm okay. I'm agreeing with it. I'm not the one that needs to push it till right now. I could have waited till August, but I'm agreeing with it for Leah's benefit. I'm good with it.
So you believe there's some value in simply finalizing things so you can move on with your life.
Yes, I understand that. Yeah.
All right. Again, this court is of the opinion that perhaps Mr. Frank is holding out hope for reconciliation. Ms. Frank was pretty adamant that there was no chance for reconciliation. The court is of the opinion that most generally, unless there's a more valid reason, that the parties are best served by finalizing things sooner than later. As a court recall, we did take all the proof. The court established jurisdiction and everything. Is that correct, Ms. Nemec?
It is. And in addition, if it helps the court with regard to waiver of the waiting period, Ms. Frank does have an active PPO against Mr. Frank currently. And there was a domestic violence charge that was adjudicated in February for which Ms. Frank was the victim. This is another reason.
That matter. Is Mr. Frank on probation?
No,
Okay.
it's really irrelevant. She just wanted to bring it up.
Okay. Is that still pending?
No,
So
it was adjudicated in February. I'm not aware of what the sentence was, but it was a domestic violence charge, originally charged as a domestic violence second offense, was pled down to a domestic violence first. Mr. Frank was the defendant, Ms. Frank was the victim.
Okay. So
Which
that
has no
PPO
bearing.
still-
Which
I'm
has
sorry,
zero.
Frank?
That has zero bearing on whether we wait till now to August, but she just wanted to bring that up. Maybe she'll
Right.
post it on TikTok again.
Well, is that PPO still?
Okay, a lot to unpack here already. So if you didn't join us at the very beginning, you might not have seen, but when we first jumped on, he spoke to her. He said, "Hey, it's great to see you, hun. I got the kids' little league pictures," and she sort of was like, "Why are you talking to me? This is really weird." And now we find out there's an active PPO. So I mean, he's slightly getting around it because they're in court and technically you're allowed to communicate in court, but he probably shouldn't have spoken to her like that at the beginning of the hearing, as we're realizing. Now he's also saying, oh, the lawyer brought this up for no reason, and that the mom has posted it on TikTok. Now that is interesting. We already know this judge hates social media. He's always like that. And yeah, her lawyer is out for blood, and she's gonna get a little bit nasty here. Yeah. Also, her camera angle is nuts.
In full force and effect.
It is, Your Honor.
Okay. And that's a separate issue from this judgment of divorce. I understand that, Mr. Frank.
I understand it. That's why I don't know why she's bringing it up.
Okay. All right.
You probably, but she just decided she needed to.
Well, people should get off social media. There's more problems caused by social media and TikTok and all that other garbage.
I don't have that. I was made aware of it.
All right. So, Mr. Frank, do you have any questions for the court?
No.
Once again, and you have no objection to the court signing this judgment of divorce today, is that correct?
No.
All right. Ms. Nemec, is there anything further from your client's standpoint?
No, nothing further. Thank you.
The problem, the reason, Mr. Frank, Ms. Nemec probably raised that issue is because the fact it gives you perhaps more reason why the parties should finalize things and move on with their lives. So there's no one's playing games here, trying to cast you in a bad light on social media. Hopefully there's no need for anyone posting this on social media. It's all a matter of public record. In any event, based upon the testimony that was provided back on May 31st, 2024, as well as the plain filed in this case, the court finds again that jurisdiction's been established. And the court further finds that there has been a breakdown in the marriage relationship to the extent that the objects of matrimony have been destroyed. There's no reasonable chance of reconciliation. The court will, in fact, act without delay and waive the balance of 6-month waiting period. Enter the judgment of divorce today. According to ordered by this court that the marriage between the parties be and is thereby dissolved, and judgment shall enter granting a divorce from bonds of matrimony. Court will sign the judgment. Ms. Nemec will mail you a copy of this judgment for your records, Mr. Frank. And with this action today, the court will cancel and vacate the pretrial conference scheduled for July 19th at 9 o'clock. No need for that, okay?
Yeah, when did the actual, payment arrangements and things go into effect? So July 1st then, or when would that?
August 1st. The Uniform Strasbourg order says August 1st.
Okay,
Is that correct, Ms. Nemec?
I believe so. I don't recall off the top of my head. I know that we had a uniform spousal support order and a uniform child support order. My recollection is that child support is actually reserved for the first year because in lieu of child support, he was going to pay non-modifiable spousal support in an amount around $3,500. And then child support would commence August 1st of next year, when the
Okay.
spousal support would then modify. He would then be paying child support in the amount of $1,100 and spousal support in the amount of $1,100 for the next 18 months.
yeah, that's all agreeable. From now till August 1st, though, I don't know if we can really, I don't think we can write this in, but so far we're still on a joint account that most of these monies are going to come out of to pay these bills, to pay the home, to pay the car. But from now to August 1st, I'm planning on paying this just as I have been, but there can't be any additional spending as there has been in this last month. And there has been, Ms. Nemec, so don't shake your head. You don't know about this. There has been additional spending and it has been unnecessary. And I'm footing the bill and I can't keep doing that. Beyond paying the home, the car, the insurance, there's Cedar Point trips now. There's well, Ms. Nemec, I just paid you and I don't want to pay you, but guess what? It came out of the account. So I don't want to, I want that to freeze though. I want to pay.
Okay. Did everybody notice her face? She's literally saying stop, stop, stop. Leah up at the top. This is a little odd, but basically they have agreed. It's a unique situation. It seems like he's not wanting to empty the account because he wants to keep the account, and he's paying all the bills for the first year by paying $3,500 a month, and she gets to keep the difference. But he's not going to give her the money, which seems like a bit of weird control issue to me. I don't know. Anyways, but the lawyer, that was such a weird move to say, hey, I just paid your bill, lady. Also, what is Cedar Point? I feel like I've heard the name before, but I don't know exactly what that is. If you guys are new here, I'm Canadian, so I don't know some common American things. So is that something I should know? A theme park, an amusement, a roller coaster park. Okay, 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 okay. Oh, it's in Ohio? Okay, okay. So she bought theme park tickets. Okay, 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 okay. Um, yeah, I feel like that might be a good idea, Andy. That's a pretty good idea. Okay. All right. I understand. This is also I've heard true. So is it very expensive, Lori? Oh. Let's just keep listening. But again, actually, I'm gonna back it up for maybe 1 minute. Watch her get quite animated at him when he starts talking about her buying this stuff.
I'm planning on paying this just as I have been, but there can't be any additional spending as there has been in this last month. And there has been, Ms. Nemec, so no additional spending. And I'm footing the bill and I can't keep doing that. Beyond paying the home, the car, the insurance, there's Cedar Point trips now. there's, well, Ms. Nemec, I just paid you and I don't want to pay you, but guess what? It came out of the account. So I don't want to, I want that to freeze though. I want to pay the bills. I want to take care of the kids, but I don't want any more spending.
Your
And
Honor,
I've
may I interject? There's a status quo in place that stays in place until the orders that were signed supplant those. The orders don't begin August 1st. They begin, I believe, July 1st.
I believe it's July.
Yes. The dollar amount that he will be paying, as I previously stated, child support is reserved for 1 year. We have a uniform child support order that will enter August 1st of 2025. He will be paying spousal support in a non-modifiable amount, and I'm trying to find it here quickly. He will be paying spousal support commencing July 1st, 2024 in the amount of $3,534.39 per month for 12 months. It was going to be paid directly no later than the first day of each month. And then commencing August 1st, 2025, he would pay spousal support in the amount of $1,100 per month for the next 18 months. Also commencing August 1st, 2025, he would begin to pay child support in the amount of $1,100 per month.
Yep. So now we know
I
those
just
things.
want to make sure that Mr. Frank understands
I
that
do.
spousal support does not commence August 1st. It commences July 1st of 2024. And until that time, the status quo order remains in effect.
Okay, so things that are above and beyond status quo that I'm not agreeing to, but that are just coming out of the account. And since it's my account, when it's depleted, I replenish it. I don't anticipate Leah just going on a spending spree, but at the same time, there's been several things that I have not approved that keep coming out of the account. And it's not, if it was, running to Walgreens and getting the kids medicine for $50, that's one thing. But right now in this time, we don't need to be taking $500 Cedar Point trips. I mean, it's just not the time.
Mr. Frank, Cedar Point tickets would not be part of status quo. Those are over and above. So
I know
Ms.
they
Frank
are.
is
And
purchasing
I-
those out of a joint account. She needs to restore those funds to that joint account. Ms. Nemec, that's the court's thought.
That my point is, I'm not trying to even get her to restore that. I'm trying to say, let's not do anymore. Okay. That's all I'm trying to say is I believe she understands that, but I just want to say,
I do.
I'm,
And I understand.
I
why don't we
believe
carry
she,
Repeat
close out?
yourself, Leah, because you were inaudible.
I said I do understand what he's saying, and I agree with that. And anything status quo, I agree.
Okay.
the problem is I wasn't asked, consulted, it just came out of the account. So you just can't do that going forward, Leah, at all.
I
Mr.
agree with-
Frank, you just heard Ms. Frank say that she understands and she agrees. So I believe that this matter is settled.
It was also understood and agreed to 2 months ago when I said stop the spending, and guess what? It's happened several times since. So
Should
I
not
just
that
want-
joint account now be closed out?
It would be closed out once the spousal support starts being paid in July. We needed to get through the rest of this month. Ms. Frank is not employed outside of the home. Spousal support is going to be her only form of income for right now. While she navigates this new change in circumstance, Mr. Frank has repeatedly expressed that he wishes for her to be able to stay home with the minor children and not have to work outside of the home. But now
Yes,
So
that
the
remains.
question is correct. Hold on. The spousal support starts on July 1st. Well, why can't Mr. Frank pay it? Why can't he close out that joint account so there are more withdrawals and expenses being paid out of the joint account? And we don't have to then argue about whether or not they're status quo.
because then she would have
that's a-
no access to funds for the remainder of the month of June. It's
Why
June.
can't he pay? Well, the only obligation he got is to pay her the spousal support for July, correct?
Beginning in July, if he would like to make that payment today, the $3,500
That's not how that,
dollars.
that's not how that works, Ms. Nemec. The 3,549 is the total sum. I paid the bills, and then the bills are deducted from that 3,549, and she gets the remainder, which we haven't figured yet, but it's right around $1,000 a
The
month.
way it does not work, Mr. Frank, is that you be enabled to give Ms. Frank absolutely nothing for the month of June. The
Right,
reason
no,
we,
that's not what I want.
This was part of a negotiated agreement that came from a mediation. And now what I hear Mr. Frank trying to do is change the terms of the agreement that was
You're right.
negotiated
The
as
terms
a
were
result of
changed.
mediation in which he signed his name.
So one thing that wasn't addressed is spending up above and beyond the status quo. And I'm
And she
telling you,
already stated to you, Mr. Frank, that she heard you and she agreed.
and I
So
stated to
again,
you that she heard me 3 months ago and agreed, and it's still not happening.
Again, the matter has been addressed. She acknowledged what you were saying on a record before this court, stated she understood, and she agrees not to spend beyond the status quo.
I'm not asking for repayment either. I don't want that. I want to just make sure if I see something come up from that, but unnecessary spending, that's all I'm talking about, Leah. That's really it. And since you've agreed, I'm good with that.
And Ms. Frank has indicated she understands that and she does not disagree with you. In fact, she agrees with you, Mr. Frank.
Okay, we're good then.
All right, so again, Ms. Nemec, again, I'm looking at the judgment, page 5, says spousal support. In answer to Mr. Frank's question, Mr. Frank is ordered to pay child spousal support commencing July 1st, 2024 in the amount of $3,534.39 for
$3,500, Mikey. Thank you. Do. Congrats again on 50K. Great channel if you haven't checked it out yet. Of course, I'm sure most of you have. That's a lot of spousal support. And remember, he's reserving the child support judgment for in 1 year. He is going to be downgrading the spousal support to $1,100 a month, and then they will add child support. I don't know if he can, and thank you again, Mikey. I don't know. I know. It's a huge amount. And again, he's unrepresented. I feel a little bit, is that how much it is, Matt? Holy shit. Well, remember that there was a DV incident that there's a TPO stemming from, Paul. That's what we know. But she needs to get a job, right? She needs to get a job. And the lawyer is being really feisty with the pro se defendant here, who one could argue, I don't know. Let's keep what?
12 months. And then commencing August 1st, 2025, the spousal support should be reduced to $1,100 for 18 months, correct?
That is correct.
And you've attached to the judgment a uniform spousal support order.
There should be 2, I believe.
Okay, maybe that's from my confusion. Of course, there's a uniform child support order, and that, of course, provides child support will commence August 1st, 2025. There's a uniform spouse support order indicating spouse support should be payable in the amount of $1,100 August 1st, 2025. I want to make sure that second order is here.
Somebody counting money there? Right loud?
We did have a hard time, Your Honor, getting signatures electronically on the 30th, and they had to be sent multiple times. And unfortunately, I don't have an executed copy in my file because I believe they all came over to the courthouse. I'm trying to find the electronic copy. There are so many copies of it because of the technological issue or the technical issues we were having that day.
Okay.
Is it
does
not
appear we need a
attached to what the
second.
court has received?
It appears we need a second uniform spouse support order. The one that indicates spousal support to be paid for the judgment in the amount of $3,534.39.
Your Honor, I'm sorry. It's because that first amount is to be direct paid. I'm sorry. I stated that multiple times. So that was not through front of the court. It was to be paid directly.
Thank you. Of course, that's corrected. This payment should be paid, made direct no later than the first of each month.
Correct.
So again, Mr. Frank, in answer to your original question, I was just looking, there's a number of documents here. Your obligation under this term of this judgment, you pay spousal support and the amount of $3,534.39 for 12 months. You pay that directly to Ms. Frank commencing July 1st. And then
Your Honor,
it'll come out of your paycheck commencing August 1st, 2025, when it goes down to $1,100 per month. And it's child support is reserved until August 1st, 2025.
right.
So we're all on the same page on that, correct?
I just so you know, the amounts are perfect, yes, but the way that the both things are structured, you know, the dollar amount of 35, 39, whatever it happens to be, is that total amount she gets for the month. And then all the bills come out of the account. That's the joint account that you see. So they come out automatically. You know, her car payment, all of it comes out. And whatever's left out of that 35.49 is what remains to her for whatever she needs, groceries, whatever, that's her business. So just so you know, the way it's structured is she doesn't just get a check for 35.49 at the beginning of the month and do whatever. So just so we're clear on that. And the second thing is I'm self-employed. So at the time where it's going to go through the front of the court in 2025, them dinner. I think they do automatic deduction as well.
Not if you're self-employed, you pay that directly in front of the court.
Starting August 1st, 2025.
Correct.
I'm sure they'll be in touch before that point.
Okay, any other questions, Mr. Frank?
No.
Anything further, Ms. Nemec or Ms. Frank?
No, no.
I have nothing further. Thank you.
All right, hopefully the parties will not be back in court soon. Ms. Frank, I understand and agrees with Mr. Frank's assessment of expenses being paid out of that account, which are not in the ordinary course of business. And with that, the court will sign the judgment and the uniform support orders, and that will conclude this hearing. Again, the pretrial conference of July 19th is vacated. All right, good luck, Mr. and Mrs. Frank. Now you can zoom out. Have a good rest of the afternoon.
Thank you, Your Honor.
Thank you, Your Honor.
Yeah, I feel somebody got screwed over in that. I don't know who it was. I actually can't tell. But something was going on there. That's weird. Good hearing though, right, guys? We are gonna watch one more, same judge, different hearing. I don't know what it's about. Let's figure it out. Yeah, right. Like that's a lot of money to pay her. Welcome, Mr. Pole. Pole. Thank you. Yay. Thank you, thank you, thank you. I think he does want her back. I think he does want her back, actually. Oh, thank you. Are you raising your hand or are you clapping? Or waving, I guess that one is it. Yeah. You guys and your funny sayings. Oh, here we go. Oh, MB, you're amazing. Do, 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 do. Love it. Love you. I hope so. We were polite to her, but it's going to be loud in here. It always is. It's busy. That's how we are. This judge makes people wait. Also, he has 2 assistants that work in the courtroom, which is pretty epic. You think so, Paul? I think somebody was getting screwed over in that situation. I couldn't tell who. And but that's because we didn't hear a lot of discovery because they settled. That lawyer wanted to settle so bad that it makes me think they were getting the better deal. But if he's willing to pay that amount, then maybe he's making a lot more money than that. Who knows? Pole. Perfect. Pole. Um, I think this is probably another divorce. We'll see. Now that's true, Cindy, but he also has to pay his. It's not like he gets to live there still. He's just paying for her house. Also, that seems like low to me because where I live, it's very expensive to live, but that's the way we do it. Yeah, maybe the lawyer screwed both of them. Yeah. If I fast forward it, it'll fuck off, it'll mess up. So we just sort of wait it out. Oh, here he is. Thanks, Judge.
For the record, this matter is before the court for continued pretrial conference. Subsequent parties have engaged in mediation with Ms. Patrick from the front of the court this morning. Present is Attorney Maria Zagorski, representing the plaintiff, Veronica Enyboik. Is your client present within your office, Ms. Zagorski?
Yes, she's right here across the desk from me. Say hi.
Thank you.
Hello.
Thank you.
You're
In
welcome.
addition, Attorney Pabi is present representing the defendant, Shima Enyboik. Good morning, everyone.
Good morning.
The court has been informed the parties have not made much progress this morning. Is that correct?
No, I don't think that that's a fair statement, Judge. We made a lot of progress. We got very, very close.
Good.
Things fell apart when we started talking about attorney fees, but we otherwise had the case settled.
Well, the party's going to spend more in the amount of attorney fees being argued about if we're going to litigate and try this case.
Agreed.
So I'm sorry. The parties have exhausted all efforts this morning. Is that correct?
Yes, Your Honor, we did our best to get this case settled, and I think we got to a settlement until the plaintiff started talking about attorney fees, and that's where we're objected, and we're not going to pay any attorney fees. And my client's ready to go the whole 9 years to make sure this case is tried if they insist on attorney fees. Otherwise, we are still open for them to the agreement we had before crept up. We're still open to that, but if they refuse that and they want to insist on attorney fees, we are ready to try this case because by the way, Your Honor, the truth of the matter is the plaintiff didn't even disclose what you asked us, what you ordered us to disclose. We did our own disclosures, the interrogatories we filed, they didn't answer, we answered theirs. We did everything we were supposed to do. They never did anything. I never got anything from them. And yet we still went ahead to talk about settling this matter. And yet they're talking about attorney fees. So they make us look like we don't know what we're doing.
We put on the record the agreement the parties have reached thus far, and you can reserve the issue of attorney fees, and the court can address that separately. Is that acceptable? When we have a short-term 5-year marriage, we'll look at the income of the parties. I mean, generally, each party should pay their own attorney fees, unless there's a significant disparity in income.
We think that she has a lot more in assets. We have let go of a lot of stuff. We were not interested in marital assets, whatever they have, the car, the house, household items, everything.
We're not going to litigate this right now. Can we put a partial agreement upon the record? Have we resolved issues of retirement benefits, spousal support, those kind of important issues?
We have some of that, Judge. Quite frankly, this is a very difficult situation for my client. She's had a lot of events in her life, and she's gone. I think I think she's just exhausted and we've gone as far as we can go today. I would like to come back to the table to finish this up, take the proofs today, sit down with Ms. Patrick after everybody's had a chance to breathe for a minute. We've been going at it for more than 2 hours, and I think it's salvageable. We just need to step away.
All right,
Yeah,
that
in
makes
response
sense,
to
Ms.
that-
Sikorsky. That makes
Yeah,
sense.
Yeah, in response to that, if this case is not settled today, we are ready to try this case, Your Honor.
All right, well, good luck getting a trial date, sir. Again, the court, Ms. Sikorsky indicates that there's still a possibility that we've made significant progress, that people need to take a breather, and then that's certainly understandable. So what the court would suggest, let's take the proofs today. We'll stop the court's clock. I'll reserve all outstanding issues. And Ms. Patrick, do you have another date for continuing mediation sometime later this month? I know at one time you had a date of the 27th of June.
Judge is sassy. Oh, he does not like it when people don't mediate. Lots of judges don't. They really don't. But also, this is sort of actually, I don't know. Is this what a mediation session is like? Because this doesn't seem like what we normally see. We normally see lawyers agreeing to things, putting them on the record. They tend to be a little more professional. This seems like a back and forth maybe that's what mediation is like. Also, we're 14 subs away from 2K. So yes, very close. Thank you for all the new subscribers tonight. It's free, by the way, to subscribe and make my night.
Available, is that still available?
It is still available, Your Honor, and that would be my first availability would be June 27th. I could
This is
do it
3
in the
weeks.
afternoon at 1:30, or I could do it in the morning at 9.
I would need the morning. I'm with Ms.
Can you give me a
LaPlante in the
second? Let me
afternoon.
grab my-
That's a Thursday, either at 9 or 1:30, Ms. Patrick, you're available?
Correct, Your Honor. Ms. Sikorsky indicates she needs the 9 because she's already in mediation with one of the other facilitators.
Right, Mr. Robbie, the court would like to one final effort of the parties to discuss and reach your own resolution. Are you available at 9 o'clock? You and your client on June 27th, which is the last Thursday of this month. It's actually 3 weeks from today. And things will be fresh in
June
everyone's
27th,
mind,
yeah.
but it still gives some time for breathing. I'm sorry, sir?
Yeah, June 27, 9 o'clock in the morning.
We'll be available,
Your Honor.
All right. Well, the court will mail out notice that the parties shall mediate with one final time with Ms. Patrick on June 27th at 9 a.m. And then subsequently appear before the court for a final pretrial conference. If we cannot resolve the matter at that time, the court would then most likely schedule a trial date. But it's a 5-year marriage. The court believes this matter should not to be resolved. In any event, the court would like to take the proofs today.
I am prepared to do that, Judge.
Court will reserve all standing issues. Mr. and Mrs. Onubike, can you both please raise your right hand to be sworn, please? Do you both solemnly swear or affirm that the testimony you're about to give this matter will be the truth, the whole truth, nothing but the truth, so help you God?
Yeah, I do.
Thank you. Mrs. Zagorski, you're going to begin with your client, please.
Yes, thank you, Judge. Would you please state your name for the record?
My name is Veronica Johnson Onubike.
And do you remember signing a complaint for divorce on February 29th of this year?
Yes, ma'am.
At the time that you signed the complaint, had you been a resident of the county of Monroe and the state of Michigan for 180 days?
Yes.
Did you and your husband have any children during your marriage?
No children we have.
Did you adopt any children?
I think I did. Oh, well, I don't know. His children. I got.
What? Was I ever expecting to? Such a weird question to be confused. I think I did. What? This seems like the type of thing that you would know. Oh my gosh. Okay, we're just gonna go back here just in a second here, just so I'm not mishearing that, right? Right?
Thank you, Judge. Would you please state your name for the record?
My name is Veronica Johnson Onubike.
And do you remember signing a complaint for divorce on February 29th of this year?
Yes, ma'am.
At the time that you signed the complaint, had you been a resident of the county of Monroe and the state of Michigan for 180 days?
Yes.
Did you and your husband have any children during your marriage?
No children we have.
Did you adopt any children?
Think I did. Oh, well, I don't know. His children. I got his children here, so I think they're my children. I think
They're your stepchildren?
they're my stepchildren.
Okay,
I sent for them from Nigeria.
okay. And are you pregnant?
No, I'm not pregnant.
Okay. And is it true that there has been a breakdown in your marriage relationship?
Yes, ma'am.
Have the objects of matrimony been destroyed?
Yes.
Is there any likelihood whatsoever that this marriage can be preserved?
I wish, but no.
Okay, thank you.
You're welcome.
That's all I have, Judge.
Ms. Gorski, it was unclear to the court. Did she adopt any children during the marriage?
She did not. She considers her stepchildren to be her children, but she did not formally adopt them.
All right, thank you.
I signed documents for them. I thought that was it. I
Right,
signed.
Mr. Bobby,
Hold on. She's saying I signed documents for them. I signed documents. Did she sponsor them immigration wise to come to America? I just feel like adopting somebody is like something you would remember. She's double secret adopted baby mama. Yeah, maybe sponsored, right? This is so weird. You guys. Oh my goodness. Also, it was notes for field trips. Oh God, you guys. This is it sad? Yes. Oh gosh.
do you have any questions of the plaintiff?
Yeah, the question I had was what you asked about adoption. We wanted to make it clear that there was no adoption. It was just, living together.
Understood. Any other
They were not,
questions?
the kids were not adopted. That
Really?
was the question I wanted to ask.
Okay. All right, if you can just confirm with your client, Mr. Chima, that he's heard the testimony of his wife and that testimony is true and accurate to the best of his knowledge, please.
I'm going to start from the beginning. Mr. Anyabike, state your name for the record, please.
My name is Chima Emmanuel Anyabike.
And when did you start living in Michigan? Is it over 180 days?
Correct, it is.
So do you know that woman that appeared before? Were you married to her?
Yeah, she's my wife.
Do you have any kids with her?
No kids.
So do you think that this marriage can be salvaged in any way, shape, or form?
The marriage has failed.
So there is no way that this marriage can be restored.
Yes.
I rest my case here on this.
Right. Ms. Gorski, do you have any questions of Mr. Chima?
I do not. Thank you, Judge.
Earl, based upon the testimony that's been presented this morning, as well as complaint filed in this case, court finds that jurisdiction has been established. Court further finds that there has been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed, and there appears to be no reason likely that the marriage can be preserved. At this point in time, the court will reserve all standing issues, or that the parties can make one final effort to mediate with Ms. Patrick on June 27th, 2024, 9 a.m. Subsequently appear before this court for a final pretrial conference. The court will mail out notice.
Thank you, Your Honor.
You're
Thank you,
welcome.
Judge.
That concludes my ever can zoom out. Have a good rest of the day.
Thank you.
You're welcome. Thank you, Ms. Patrick.
Yeah, where
You're
are
welcome,
those
Your Honor.
kids? Okay, what's next, Judge? Oh.
Good morning, Ms. Hicks.
Morning, Your Honor.
Good morning, Miss Hicks. Good morning, Judge Bromlick.
Okay.
That's this judge.
Mr. Wilkerson is present. He's out in the hall.
Okay.
So we just have him come in.
Phone further
Log on,
away.
in the hallway. For the record, Mr. Wilkerson, you are Dwayne Wilkerson, correct? All right, good morning. For the record, well, let's just change color. Mr. Wilkerson is personally present this morning for possible contempt proceedings. He has presented to the court a copy of a child support receipt that he paid $500 this morning. Also present, appearing via Zoom, is Morocco in front of the court attorney Rebecca Hicks. Good morning, Ms. Hicks and Mr. Wilkerson.
Morning.
Ms. Hicks, are you aware that Mr. Wilkerson did in fact make a $500 payment toward his child support arrearages?
Yes, Your Honor, that's reflected in our system.
Okay. Mr. Wilkerson, did you pick up a packet to file a motion to reduce your support?
Yes, I
Okay.
did put one in before, but I got the date confused what it was the other day. That was my fault.
You didn't appear and got dismissed, and you also got a copy of the jobs list, correct?
Hi, Chris. So nice to see you. You came just in time for somebody to have a contempt hearing. Mr. Paulet, we love contempt hearings. This judge, we'll see what happens. We shall see. I'm calling the big D dismissal because he loves it when somebody pays $500 with a receipt. Oh, you speak in the judge's language. Just disparage TikTok a little bit. Oh, he's gonna love you.
Good. All right, so Mr. Wilkerson has done what the court has suggested. Mr. Wilkerson, you still have pretty significant outstanding arrearages. I mean, this is a arrearage where the Attorney General may very well pick up this case. Is that correct? And Ms. Hicks, and charge Mr. Wilkerson with the felony of non-support?
Yes, Your Honor, his arrears balance is over $20,000 at this time, so this would be a case where the Attorney General could potentially review it and charge him with a felony.
Right. Right. Mr. Wilkerson, the Michigan Attorney General has been charging people in the state of Michigan with a felony criminal charge of felony non-support, punishable by prison. When the arrearages are this high, I'm just warning you, you need to really focus in and get this matter addressed. And I don't know if you have a relationship with Ms. Spain, the mother of your children, if she can waive some of those arrearages. I'm just saying you got to get this really quick, get this down because it's on their radar. And okay, I'm just telling you, if they do authorize that and you get arrested, the criminal court must set a bond amount of 25% of the arrearages, cash only. So we'll be looking at coming up with $5,000 minimum cash only to post bond. Other you spend all summer in jail. So really focus in on this, and yeah, be proactive. At least from this court's perspective, be proactive. File a motion to reduce your support. Show up for that hearing, and make payments in the meantime. Even if you got to mow grass, whatever you got to do to pick up, make regular payments. Right. In light of the fact that Mr. Wilkerson has done what the court suggested, Ms. Hicks, do you have an objection to continue this for another review?
No, Your Honor, I would propose that we adjourn this to July 30th at 8 a.m. back on my regular docket to allow him the opportunity to get his motion scheduled. And even if the motion doesn't take place prior to then, hopefully he will at least have that in place.
All right. All right, Mr. Wilson, you've done what the court just suggested, and the court appreciates that. So we're going to take this off the court's docket, and you'll be mailed notice to appear before Ms. Hicks. You can appear via Zoom on July 30th at 8 a.m.
See, I told you the
What's the
500
mantra
was
that-
up.
8 a.m., July 30th. And the order that you'll receive will have Ms. Hicks' Zoom ID number. Or you can appear in person if you want that morning. She's going to look to see have you made payments between now and then. And have you filed your motion and appeared for that motion hearing date? The sooner you get that filed, the sooner you can get action. Even let's say that you file it this week, but the hearing is not for another month. Any modification reduction goes retro to the date you filed your motion.
Last time they said they didn't get it, and then when they said they got it, I didn't realize they gave me a date. I thought it was the same thing.
Well, make sure that the front court has your valid address down there. And you're checking your mail because I'm mailing you notice. Is there anything further than this morning, Ms. Hicks?
Nothing further on this matter, Your Honor. Thank you.
Mr. Wilkerson, any questions?
No, there are no questions.
Okay, good. You're good to go. Have a good rest of the day. And
Free till the end of July. I called it. I knew 500. You show up in there with a 500 receipt, you're getting out.
okay, you have some cleanup matters. My wife took Liam to his piano lesson last night. She was just really impressed. She really likes that instructor.
Yes, she's really great.
And you hope if you have I don't know how old she is, but obviously she's younger. If you have a teacher, that's going to inspire the boys to keep, practicing.
Everybody's here on that mediation.
Okay. Can we just recess for a minute? I've just informed Miss.
That's exactly what I just said. He has a young child. No fucking way. Even his voice sounds old. I love this. This is how we find out the lore of all of these different judges. And I've actually done, for some of our members only, I've written like fictional stories where I create backstories about the different judges that we watch a lot. That's the kind of weird shit we're into around here. So yeah, hit that sub button.
Brad has 2 parties and 2 attorneys present. I just finished up mediation. Maybe we can capture that real quick.
Absolutely. I'll just turn off my video and wait till you guys are completed with them.
Thank you.
I know, but part of it is difficult. We're watching a very wide shot of him. We don't shame anybody around here, Max. Plus, I like older guys anyway.
Thank you.
I have a thing.
Yes.
Court is now in session. Judy Dutterstad versus Donovan Runkle.
For the record, this matter is before the court for actually pretrial conference scheduled for tomorrow, but the parties engaged in mediation with Ms. LaPrade for the front of the court this morning. This pretrial conference is being conducted via Zoom. President Attorney Kirsten Nemec, representing the plaintiff Judy Duderstadt. Mr. Duderstadt is present. In addition, Attorney Kimberly Kuhn is present, representing the defendant Donovan Runkle, and Mr. Runkle is present. Good morning, everyone.
Good morning, Your Honor.
We have a 7-year marriage. Were the parties able to make any progress this morning, Ms. Nemec, Ms. Kuhn?
Yes, Your Honor, we have a full agreement.
Wonderful. Who would like to place that agreement on the record?
I can do that, Your Honor.
Please, Ms. Nemec.
So the parties have a marital home, which is awarded to Mr. Runkle. There will be no equity paid to Ms. Duderstadt for her interest in that property. Ms. Duderstadt will be able to remain in the home for the next 90 days. While she is in the home, she will pay the DTE bill, but Mr. Runkle will be responsible for all other expenses related to that home. In consideration of the fact that Ms. Duderstadt has paid his car insurance for the next 6 months and is not seeking reimbursement for the same. With regard to personal property, Mr. Runkle is awarded the 2015 Ford F-150 and the 1993 boat. I don't remember its make and model, but there's only one boat. So he gets the boat. Ms. Duderstadt will be awarded the 2014 Ford Taurus. Each party is responsible for all costs, fees, and liabilities associated with the items of property that they're awarded, and will hold the other party not liable. Sorry. As far as personal property goes, each party is awarded their own premarital personal property. And there has also been a list that was passed back and forth with regard to personal property. So there are some understandings there as well. But the personal property will be divided by agreement. If there is any disagreement, the parties agree to engage in binding arbitration with Mr. Godfrey. Each would be responsible for half of the costs of that arbitration should it be necessary. And that arbitration would need to be requested within 30 days of Ms. Duderstadt vacating the marital home. Otherwise, if it's not requested, each party will be entitled to keep whatever personal property is currently in their own possession. To each party in their own name. There are no joint bank accounts. Each party is entitled to the entirety of the retirement account in their own name, investment accounts in their own name as well, and each party is responsible for the debt in their own name. Ms. Duderstadt will be keeping or retaining the ownership interest in Midwest Veterinary, is it practice? Partnership. She free and clear of any right, claim, or interest of Mr. Runkle. Mr. Runkle will receive back Ms. Duderstadt's engagement ring in exchange for the party's dogs. Ms. Duderstadt is entitled to possession and ownership of the dogs.
What? Hold on. Hold on. Hold on, hold on, hold on. Did we just hear of a dog ransom to be paid for the ring? I swear to God, that's what they just listed off here. The dog ransom. What is going on? Dog for the ring. Why would you want the engagement ring back? Unless I guess it's a family heirloom. In that case, I would give that back to somebody. I sold my wedding band and engagement ring because I needed money when I was young and divorced. And I wish I could have kept it, but I didn't. So, um, but I would have laughed if later on my ex-husband was like, I'm gonna need that ring back. I've been like, okay, well, maybe you should have paid fucking some bills then. So, uh, this is weird. I'm just gonna back that up for like a second. Oh,
Ms. Duderstadt is entitled to possession and ownership of the dogs. No spousal support is awarded to either party, and the same is forever barred. And finally, Mr. Runkle will immediately release Ms. Duderstadt's cell phone number so that she can establish her own cellular phone account with that same number. And I believe that's the entirety of the agreement.
Thank you, Ms. Nimick. Ms. Kuhn, did Ms. Nimick accurately state your client's agreement?
Just a couple of things. If the parties have any life insurance policies, they would also be awarded their own. I'm just trying to clean up just some of the provisions. Ms. Nemick did an excellent job though. With regard to the engagement ring, it's actually a wedding and engagement ring. It's a set. So he would receive that wedding and engagement ring back. And is there a date that we can put down that?
Oh, that seemed to bother her. Both of them. These are good cases tonight. The cell number, that's hilarious, I guess. I understand it. I've had the same phone number since I was 14 years old. But then pay your own bill, I guess. That's the beginning of it, you know? You know. Yeah, and we try and find these kind of cases every single day. I have so much fucking court in my computer that we haven't watched yet, and I get new stuff every single day. I have an addiction to downloading and watching court. So join me, won't you?
He can expect to get those back.
Well, I would think as they're exchanging personal property, once they've finalized that, that's when I think she could turn over the engagement rings.
But if she's gonna
the
take the
sets.
dogs, or, well, it was the dogs for the engagement and wedding rings. So can we say that at the point in time that she's vacating with the dogs, he will at least have the engagement and wedding ring at that time?
Yes, that's fine.
Okay, very good. And they each pay their own attorney fees. They're also each responsible for their own insurance and any medical bills that would result. Your Honor, with regard to the vehicle insurance, that bill is in the plaintiff's name. It was paid until October, so my client's not going to have to pay her any money towards being having that insurance through October, but he's also going to be insured through that date. So those are the only, I just want to make sure. There's no deed required for the house either, Your Honor. It's just in my client's name. And I don't believe there's anything else, correct?
I think that covers it.
Okay, I think we're covered. Thank you, Your Honor.
Right, thank you, Ms. Kuhn. Ms. Nemick, were those clarifications acceptable?
Yes, they were. Thank you.
Very well. Ms. Duderstadt, Mr. Runkle, can you both please raise your right hand to be sworn, please? Do you both solemnly swear or affirm that the testimony you're about to give in this matter will be the truth, the whole truth, nothing but the truth, so help you God?
Yes.
I'm sorry, Mr. Runkle, we couldn't hear you?
Yes, sorry.
Thank you. All right, thank you. All right, Ms. Nemick, you can begin with Ms. Duderstadt, please.
Okay. Judy, could you state your name for the record?
Judy Duderstadt.
Okay, and you are the plaintiff in this action for divorce, correct?
Correct.
At the time that you filed your complaint for divorce, had you lived in the state of Michigan for at least 180 days and also in the county of Monroe for at least 10 days? Children born of this marriage. And you're not currently pregnant, right?
Correct.
Okay. And are you stating to this court that there's been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed and there remains no likelihood the marriage can be preserved?
Correct.
You heard the agreement as I placed it on the record and the clarifications that Ms. Kuhn placed on the record.
Correct.
Did you understand all of it?
Yes.
Did it reflect accurately the agreement you believe that you're entering into?
Yes.
You have any, oh, I asked you questions. Have you had time to think about it?
Yes.
Have you had time to discuss it with me?
Yes.
Do you understand that you could have taken these issues to trial and asked the court to make a decision, and then that the court's decision could have been different than the agreement that you reached today?
Yes.
But rather than do that, you're asking the court to adopt the agreement that we just read into the record and make it a judgment of divorce.
Yes.
Have you disclosed all of your assets and liabilities to Mr. Uncle?
Yes.
Are you satisfied with my representation?
Yes.
I have nothing further, Your Honor.
Thank you, Ms. Nemick. Ms. Kuhn, do you have any questions, first of all, for Ms. Duderstadt?
I do not, Your Honor. Thank you.
Questions for Mr. Runkle, please.
I do. Thank you. Donovan, can you state your full name?
Donovan Ashbrook Runkle.
Donovan, you heard the agreement that was read on the record?
Yes.
Do you understand all the terms and conditions of that agreement?
Yes.
Is it true that you and I have had an opportunity to discuss all the issues that make up this agreement prior to mediation?
Yes.
And do you have any questions with regard to any of the terms and conditions of this agreement of either myself or of the court?
I do not.
Are you representing to the court that this is your agreement today?
I am.
And you understand, Donovan, that had we gone to a final hearing in this matter, the result could have been better, it could have been worse, or the same.
Correct.
And notwithstanding that fact, you're asking the court to adopt this agreement and make it an order of the court, correct?
Correct.
Has anyone threatened you, induced you, or forced you into entering into this agreement?
No.
You're doing this of your own free will.
Yes.
And you understand that with regard to spousal support has been forever barred as to both parties. That means you and your wife are waiving your statutory right to ever request petition the court for an award of spousal support. You understand that, correct?
I do.
Are you satisfied with my advice and counsel?
I am.
Have you made a full disclosure of all your assets and liabilities in this case? No further questions.
Thank you, Ms. Kuhn. Ms. Nemec, do you have any questions of Mr. Ronco?
I do not, thank you.
You'll prepare the judgment, Ms. Nemec?
Yes, I will.
Well, the court would like to thank and acknowledge Ms. LaPrade for her assistance in helping facilitate a resolution, as well as, of course, attorneys Nemec and Kuhn for helping the parties reach their own agreement. And the court would applaud you, Mr. Ronco, and Ms. Durstaff for reaching your own agreement. It's without question the best resolution, rather than this court decide these matters. Keep in mind, you will not be divorced till the court signs written judgment. Hopefully that will be in the next couple of weeks. With this agreement, of course, the court will vacate and cancel the pretrial conference scheduled for tomorrow morning at 11 o'clock. Thank you, Ms. Nemec and Ms. Kuhn, for being proactive and moving these matters forward and scheduling mediations at that's good with your respective schedules. Based on the testimony that's been presented this morning, as well as the complaint filed in this case, court finds that jurisdiction has been established. Court further finds that there has been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed and there appears to be no reasonable likelihood that the marriage can be preserved. According upon receipt of the consent judgment, the court will sign that judgment, and at that time, the court will order that the marriage between the parties be dissolved and judgment shall enter granting a divorce to bonds of matrimony. Good luck to both of you. Thank you again, Ms. Kuhn and Ms. Nemec. That will conclude this matter. You can everyone zoom out and have a good rest of the day.
Thank you, Your Honor. You too.
Thank you,
Thank
sir.
you.
That's a good question. Now let's hear if he talks any more about this violin lesson.
Thank you for your flexibility.
Of course, it's always important to get those settlements on the record when they're ready.
Okay, we're ready whenever you are.
Okay, the first I have is a bench warrant to cancel Daniel Slaughterbeck II versus Caitlin Heyer, case 2022-007058 DC. Mr. Slaughterbeck made payment and came in and picked up the jobs list and will be applying to 5 jobs per week between now and the adjourned date. Friend of the court would like to cancel his bench warrant and set a short review to July 9th at 8 a.m.
So ordered.
The next is Tracy Wilson versus Gerald Richards, case 2018-005219 DS. There was a referee recommendation for a bench warrant. Mr. Richards has substantially paid off his arrears. Friend of the court would like to set aside that authorization for a bench warrant and set a review for August 6th at 8 a.m.
So ordered.
And the next is Jacqueline Howard versus Randy Mays, case 2007-002-622 DP. This case has a referee recommendation for the bench warrant. Mr. Mays contacted friend of the court and has made some substantial payments on his arrears. So friend of the court would like to set aside the authorization for the bench warrant and adjourn this matter to July 30th at 1 p.m.
Ordered.
And then I have 6 bench warrants in your queue from a referee. They're for Mark Mayer II, Robert Bayshaw, Nicole Destiger. There are 2 for Nicholas Castelnero and 1 for Malachi Parker. They all had hearings with referee McKee where they failed to appear. He recommended that a bench warrant be issued. The 21-day objection period has passed with no objection being received, so those can be signed by you to go on lien today.
Very well. So ordered.
Okay,
That's
so
it?
ordered. That's it. But I think we have time for one more short case before we say good night for the evening. I'm drinking my Tim Hortons coffee, by the way. Somebody mentioned Tim Hortons. I love Tim Hortons coffee. The referee is like a judicial official who makes recommendations for the court. I'm probably going to create frame. Give me 1 second.
Specific.
Oh,
Okay, we'll wait for Mr. Soteropoulos to.
Yeah, he's getting his quiet.
Court is recalling Kristen Keister versus Dwayne.
Oh, recalling. So here's where I'm disorganized. Let's just make sure. I think they might have had a one before this. Oh, hold on. Start here. Yeah, she looks like she's crying in that other video, right? Look.
We're back.
Yeah. Oh, she looks like she's crying. Okay, let's see what happens. So we'll start here.
Court is now in session. Kristen Keister versus Dwayne Pennant.
For the record, this matter is before the court for a pretrial conference. The same is being conducted via Zoom. Present is Attorney Matthew Motley, representing the plaintiff, Kristen. Is it Keister or Keister?
Keister.
Keister. Good morning, Ms. Keister. In addition, Attorney George Soteropoulos.
Perfect, Judge. Thank you. Yes.
Good morning, Mr. Good morning, sir. Is present representing the defendant, Dwayne Henning, and Mr. Henning is present. Good morning. I know the parties conferred with Mr. Walker for the front of the court this morning. Do the parties have any resolution or agreement?
We've agreed to return to mediate with Mr. Walker on July 24th, Your Honor, at 1:30.
That is correct.
Mr. Motley, that's good with everyone's schedule?
Yeah, we plan to just use this time to exchange some documents. I don't think this is going to be a lengthy discovery period at all, but we obviously want to reduce the cost for everyone involved. We'd like to mediate with the FOC, have a chance to exchange some basic employment information just so that we can go in there and try to resolve it all on that date.
Well, of course, one solution is we can, if parties can agree upon custody and parenting time this morning, we can refer the issue of child support to the front of the court for a formal investigation recommendation. And typically they'd get financial documents from both sides. They'd issue a recommendation. Each side would have 21 days in which to object to that recommendation before it became an order of the court. That is one very efficient solution. But
Your Honor, I know the parties have been operating. There is no order, as the court's aware, but they have been operating on a parenting time schedule. We would be in favor of that, but I can't speak for Mr. Motley and his client to continue that schedule and reduce that to an order. But I think that may be an issue for the other side.
I would, yeah, if the court's inclined to have an investigation to happen here to get an interim temporary order, I don't have an objection to that. However, I'm pretty sure brother counsel and I can work out an interim order between now and July. But right now, that is correct. They kind of operate on their own parenting time schedule.
Okay. I'll leave it to counsel. I mean, I'm just offering a suggestion. If we were trying to keep down expenses and involvement, obviously Mr. Walker's available this morning if you need to talk with him for another 15, 20 minutes to fine tune this court starts with a position that the parties should share joint legal custody. So they share equally in major decisions between the welfare of the child or children. And this court is not getting hung up on physical custody, simply legal custody and parenting time.
Your Honor, would it be possible to put Mr. Motley and I in a breakout room for a second?
Certainly. Do you want Mr. Walker or not? Just two of you?
Just the two of us right off right now, if you don't mind.
Yeah, we do that.
Okay, we can do that.
Yeah, it looks like a
We'll
victim.
put the parties in a waiting room and counsel in a breakout room.
Thank you, Your Honor.
You are welcome.
A few moments later.
Record on this matter, counsel and the parties are present and they have conferred further this morning. Counsel, be able to come to any closer toward an agreement?
Yes, Your Honor.
Yes.
I know I've.
Good night, Andy. I was just joking about her having fingerprints of victims. Yes, I'm a SpongeBob fan. Oh, I'm just a mean girl.
spoken with my client. I believe Mr. Motley also has spoken with his client. We are in agreement on an interim order of joint legal custody. And the parenting time schedule will continue on an interim basis. It's a 2-2-5 schedule, Your Honor. And both parties, based on that schedule, have equal parenting time. There is one minor detail we're trying to work out, refusal and the detail. And hopefully Mr. Motley and I, between now and July, can work that out with our clients. If not, we can proceed to mediation with Mr. Walker, and we can work on that.
And what time was the schedule on? It's on 1:30 on the 24th of July. Is that correct?
Yes, Your Honor.
All right. So perhaps the court could take some brief testimony from the parties. They can both verify their adherence to this agreement. They believe it to be in the best interest of their child, and the court will simply continue the matter for continued pretrial conference subsequent to the July 24th 1:30 mediation with Mr. Walker. And the court will mail out notice that's that date and time, if that will work with everyone.
Yes, Your Honor.
Yes, Your Honor.
And at least by entering a temporary, on the record, a temporary custody order this morning, it'll stop the court's clock. So I appreciate that, counsel. All right, Ms. Keister, Mr. Henning, can you both please raise your right hand to be sworn, please?
Raise your right hand. Wait.
Do you both solemnly swear or affirm that the testimony about to give this matter will be the truth, the whole truth, nothing but the truth, so help you God?
Yes.
Yes.
Thank you. All right, Mr. Motley, if you're going to begin with Ms. Keister, please, just to confirm with her understanding of this arrangement and her belief that's the best interest of minor child at this point in time.
All right. All right, Ms. Keister, did you hear the agreement placed on the record?
Yes.
You're understanding that you're agreeing to enter into an interim temporary order that awards both parties joint legal custody?
Yeah.
You understand that might include that pretty much any decision relates to a medical decision, educational decision, religious upbringing, anything pertaining to that, that's going to be something that you and defendant father have a 50-50 decision-making power in, correct?
Yes.
And you believe at this point in time that that temporary while that temporary interim order would be in the best interest of your children?
Yes.
You understand that on an interim and temporary basis, you're entering into a parenting time schedule that's 2-2-5. And as I understand that, that's you having Monday, Tuesday, dad having Wednesday, Thursday, and the parties alternating weekends, or is it the other way around?
The other way around.
So dad, defendant father would be having Monday, Tuesday. You have Wednesday, Thursday, and you guys alternate weekends?
Yes.
And at this point in time, you believe that arrangement on a temporary and interim basis is in the best interest of the children?
Yes.
Your Honor, I don't have any further questions at this time. The only thing that I ask, and I don't think this is very different than what we put on the record, is that the matter of parenting time still be reserved.
Well, it's a temporary, according to understand, this is a temporary basis. We can revisit this when we come back on July 24th. Thank you, Mr. Motley. Mr. Soteropoulos, do you have any questions, first of all, for Mrs. Keister?
No questions from Ms. Keister, Your Honor.
Questions for Mr. Henning, please.
Mr. Henning, you heard what was placed on the record, whereby you and Ms. Keister will have joint legal custody of your daughter.
Yes, sir.
And that the current schedule, which is a 2-2-5 schedule, will continue on an interim basis?
Yes, sir.
And you believe that that's in the best interest of your daughter?
Yes, sir.
Your Honor, I have no further questions.
Thank you. Mr. Motley, do you have any questions, Mr. Henning?
I have no questions for Mr. Henning, Your Honor.
Very well. I'll leave it to counsel as to whether or not you want to prepare a temporary order in that regard. Otherwise, it's noted for the record, and we can simply finalize things when we appear back on July 24th. The court finds the agreement of the parties, the parents, to be in the best interest of minor child. Obviously, the parents know what's best for their child, and so the court will adopt that agreement and mail out notice of a continued pretrial conference subsequent to the July 24th 1:30 mediation with Mr. Walker. The court will provide you with Mr. Walker's Zoom ID number in that notice. The court would like to thank and acknowledge counsel for their efforts this morning, and the court would applaud you, Ms. Keister, Mr. Henning, for reaching your own agreement. Your child will flourish when you can work together for course, nowadays with the pleadings, we don't know if it's your son or daughter, but anybody, your 5-year-old child will do well when you're on the same page. So it's a great start, and I applaud you for that. And there will be bumps in the road in the future, but effective communication will, you can address those bumps. So there's enough challenges in life. Make it good for each other and your child. So I applaud you for reaching this agreement on a temporary basis, and hopefully you can continue to build upon those agreements in the future. Anything further this morning, Council?
Your Honor, only that, I'd like to thank you for your patience and understanding and guidance this morning. And I look forward with continuing to work with Mr. Motley to resolve this.
All right, absolutely.
I would echo that, Your Honor.
All right, you'll do some discovery in the meantime regarding income and so forth, so that we can come back and address child support. If, of course, if we can't reach agreement, we can always refer to the front of the court for formal investigation recommendation. And will they all get copies of W-2s and recent pay stubs and so forth, and tax returns? But if perhaps the council can work through that together.
Yep, I don't think that's going to be.
I'm confident we can.
Yep.
All right, great. All right, well, that will conclude this hearing. Everyone can zoom out. Have a good rest of the day.
Thank you, Judge. You do the same.
Take care.
Thank you.
Thanks.
Classy act, you guys. Classy, classy. What a classy lassie. That was a nice ending. I think that's good for tonight. That's been an hour and a half. I got to go make those into videos now, because I think that those are pretty funny. Full evening. If it was you've subscribed, we go live every single day, plus videos, and twice on Sundays for members only, and Sunday Court Watchers Anonymous. Reminder, tomorrow is Friday. No, is it? It's Friday. Tomorrow's Friday. Had to double check. Tomorrow's Friday. Okay. So yeah, we made it through the week. I hope that everybody is ready for the weekend. I will be looking for the great court that we will watch tomorrow night. Since let's be real, none of us are going on dates tomorrow night, right? Anyways, okay. Reminder, I love you. I am proud of you, and I will see you in the next video. Bye.